All right.
Wednesday, August 18th,
Josh,
2021.
is your microphone on?
Got cut off. There we go.
Thank you.
Roll call, please.
Gary Harris.
Josh Young.
Kristen Hansen.
Maggie Wentler, Brittany Cotner.
Are there any additions or deletions to the agenda? Hearing none, I'll entertain a motion to approve the agenda.
Motion to approve.
I'll second. All those in favor?
Aye.
Aye. All those opposed, motion carries. All right, on the agenda item, there's a lot of, this technically is not a public hearing, but based on the interest, I think it would be best to have some input from the public. So we'll move on to new business. It's going to be consideration as to the status of the conditional use permit for Pine Trail Homes. What I would like to do is give each, if somebody wants to make a public comment, I'll give you 5 minutes to make the public comment. I want to tell you that we have all read your letters, so I don't want it to be a rehashing of the letters that we already have read. So if you have any new comments, perhaps you have a question for the city attorney, I'll give you the opportunity to speak now. You state your name.
Hi, thank you. Mark Severson. I'm an attorney working on behalf of Clark Lake Conservation Association, most of whom are present tonight. At least 1/3 of the entire association is here. I'll just touch briefly on some of the technical points that I'd like to make before giving way to who is here tonight. You know very well the history of this CUP. You know some of the problematic things at the beginning with Outlot C becoming Outlot H, and ultimately the development not being acted upon. Based on that, you received a sound opinion from your city attorney opining that the CUP was void by lack of development under your own ordinance. We agree with that position. In time, there was an extension of the CUP, although that in hindsight, that might appear as a mistake. It ultimately doesn't matter because the original CUP was rendered void. And then fast forward, and ultimately what happened is a dock was placed in the questionable spot at the end of what should have been Outlot C. And that is really the ultimate issue here tonight, at least presently. We're here to ask that the dock not be allowed, period. The spirit of the original CUP, in fact, the language did not allow a dock. We don't think it's healthy for a city to allow a developer to benefit by the passage of time and some violations, just only to come before you now and be allowed to have a dock, even if there's a number of reasonable conditions attached to that. So we would ask very strongly and firmly that the city, if it is to deem the CUP in effect, okay, then let's enforce it. There is no dock. Let's make sure there's no dock and strongly enforce the original CUP. If it's not in place, then let's respect process. Deem the CUP void and require a new CUP to be applied for. That would allow those who are interested here tonight to have the due process necessary to voice their concerns. And not just that, if you hear a lot of the concerns has to do with the placement of a dock and the impact that's going to have inevitably on Clark Lake. You could go as far as requiring an environmental assessment worksheet. You know, if the questions are environmental in nature, it would sure be nice to know what is the impact of this dock in the first place. We can all have our opinions, but it would be nice to have some actual data to inform us. So ultimately, we ask that there be no dock whatsoever. And that would be the proper decision for the city. We discourage the city from allowing the fear of litigation to be any motivating factor. I think the city's in a rock and a hard place, regardless of what's being done. You're probably looking at litigation. So I would encourage you just to do the right thing. ultimately, you've heard our position through all the letters and statements here. If the dock is allowed to be in place, that is not a concession, but I did place before you added conditions that should be considered. But again, I want to be very clear that there's absolutely no concession and we do not want the dock in place. So I'll now yield to others present. Thank you.
Jane Aarons. Anything else you want to know about me? You already know it. Okay. As you know, this dock is basically a toe hold, and it's the rest of the toes and the whole foot is the next concern. As I understand from the DNR hydrologist, is that this commission and the city of Nisswa has control over whether a dock is present, whether extensions go in. The only time the DNR comes into play is for mooring slips. So the ultimate decision about whether there's a dock and then extensions into open water falls on your plate. And is that something that the city is willing to take on and wants to enforce and wants to deal with down the road, something that's going to be very difficult to enforce? And the original CUP, I just question what was wrong with that. You know, that was fair. It was fair to everybody. There was access. So what's wrong with that? And so what justifies, what justifies somebody getting more than they deserve? So if you give him what he asked for, that's great. Give him what he asked for originally in the CUP, that's great. But you shouldn't be rewarded, thank you, for someone unapologetically breaking rules. And that's what's happened here. Breaking rules and then coming and asking, not just for, they don't ask for forgiveness, they ask for more. And that's not fair. So if fairness is a process and a fair outcome, then how is it fair when the only party that breaks the rules has the opportunity to win? How is that fair? That's not fair. We haven't broken any rules. We've abided by your process. We've been patient. We've done everything we've been asked to do and more. And so ultimately, the association, all of this will fall back on the association to determine whether or not something is being violated or not violated. And we turn into the Clark Lake cops. And that's not why we're here. This is our home. This is where we put our roots down, where many generations have put their roots down. And we have worked hard as an association to keep our home healthy. And our home is that lake. So we're the ones that are affected, not a developer, not a name, not even potential owners in the development. They're not the affected ones. So we work hard to keep this lake protected, and we'll just ask you to do the same. Thank you.
Hey there, Chuck Mueller. I live 8 lots south of the Pine Trails. I sent an email today, 4 points. So just to summarize, I want to advocate for the wildlife. We've got 1 pair of loons, 1 pair of cranes, 1 pair of heron, eagles, bears, right there, right where this dock is. 45 houses, 45 boats. I'm assuming that's not going to be a safe environment for that wildlife. Oh, by the way, we did have our pair of loons get injured this year up in that area. Second of all, the townhouses on Norway Lane, nobody talks about that. They have a bench. And I believe this body or the city of Nisswa said, no boat dock, a bench 10 years ago, 20 years ago, because of the environmental issues. what will they say if a conditional use permit is granted? They're gonna want the same rights as the Pine Trails lot. Why wouldn't they? I want to sell my townhouse. Wow, look, I can represent access, riparian rights. That's a no-brainer. So there are, I believe, 8 townhouses. They'll come to this committee for a permit so that they now can have access. Playing fairly, riparian rights, what does that mean? According to Minnesota statute, out to the navigable channel. How is it possible that a channel is dug straight south, intersecting another property owner's outlet to the channel in this situation? I mean, I've been on the water for 50 years, and the channel out to navigable waters goes straight out. It doesn't go south. In this case, that channel should go east. And guess what? If it were to follow those rules, it'd go out 300 feet through sensitive wildlife area. And that was too hard, or that permit wouldn't have been allowed. So what do? We take the shortcut, we go south along the shoreline 50 feet, and we intersect somebody else's right out into the navigable waters. That's a shortcut, and that's not fair. And then finally, just as a member of the association, I have 200 feet of shoreline, and I get assessed over $3 a foot to pay my dues, to keep the water clear, to cut the weeds, to ensure future generations of value on Clark Lake. And now I have a little 51-foot sliver lot for 45 houses that can basically pay $150 or $50 a year and launch those boats, and I'm paying over 600. That's not fair. So another shortcut, please do the right thing. Take the boat dock out. When I had a conversation with the prior owner, Al, he said, yeah, really would just like kayaking and canoeing. No way motorized boats. No way. He died. But that's his legacy. He never intended this to have motorized boats. He never intended to have a boat dock there. Do the right thing. Take the boat dock out. And those Pine Trails lots do not have riparian rights to Clark Lake. Thank you.
Good evening. My name's Rick Rudolph. I happen to be a new resident of Pine Trails, so before you start throwing vegetables at me, I just would like to say, first of all, when I was considering the purchase of our home there in Pine Trails, it was never represented that that property there would have the lake access for motorized vessels. You'd never be able to keep a boat there to moor it, to launch it. The only thing that was ever represented was that it was walk-in use only. And frankly, going down and looking at that access, it's abundantly clear that that's the only thing it could ever be used for. The other thing that I guess I would make note of is that the dock, while it does go through some sensitive wetland areas at the beginning, it is the most environmentally responsible way to be able to access the water. Otherwise, you've got people walking in, knocking down the habitat and the growth along the shore, which would be significantly worse than anything that this dock is going to do, which is just allow you to put a canoe or a kayak or a paddle board in the water. There is no way that, I would be absolutely crazy upset if I thought that there were going to be 45 wake boats all parked on a 50-foot lot at the, on my lake, getting up at, O Dark 100 to get the great water. So, but that's not what's going on. I mean, this dock, you can sit on the end of the dock and look at the loons. And in terms of loons that may have been injured, I never saw anybody use that waterfront this past year. So I know it wasn't anybody in Pine Trails that did it. So I would urge you to maintain the dock as it is. You don't have to do any extensions of it. There's no plan. And if there needs to be some further restriction to make it more clear than I think it already is, that it's all non-motorized use, that seems entirely rational. But to require that it be removed, I think is unnecessary and inappropriate. Thank you.
Josh Miles. Do you need my address? So thank you guys for your time. The reason I want to come up and say something is, to me, it seems like it shouldn't be a conversation as to whether or not the dock can be there or not. The dock's never been allowed. It was never granted in the first place. And furthermore, the fact that he put the dock in, or the controlling interest, when they weren't supposed to have it in the first place, where do we, you've already been documenting these people that are pushing the envelope. Where does that end? And, it's fine that this is what they want to do, because I think frankly, based on, prior potential exposure, if this comes out, and then further sales, this is coming from somebody that's got no future skin in the game. They're gonna sell their 60% or whatever, and they're completely out and they're not calling any shots. But I think when you couple that with the fact that they've already been in violation, I just have no idea where it stops. And I think the meeting should be more about how we prevent them from not being governed properly. Thank you.
Any other public comment?
Jamie Den Hartog. Yeah, DENHARTOG. Yeah, I live on Clark Lake, and I just think this is a very slippery slope. Because where does it end? You guys are on this council for 8-year terms, whatever it may be, but thinking 20, 30 years from now, I just think it's a poor decision and it will have implications. We have the luxury of seeing lakes south of here and how they've used their ordinances maybe poorly. And we have that luxury of seeing that and saying, hey, well, we can do something about that. Well, that's now. So, thank you.
I wasn't going to say anything, but I am. I'm Frances O'Neill. I too am a resident of Clark Lake. I have been to several committees before, not very successfully, but I've been here. I think the comments that you're hearing, in addition to what we put into our emails, kind of even go beyond all this. This is our environment we're talking about. We're living in a time right now when we're seeing forest fires, we're seeing floods, we're seeing erosion. And you know why? It's because people like us didn't make a stand 40 years ago, 50 years ago. Those are some of the people we should blame. So let's not us take the blame. Let's do the things that are reasonable. There is public access to Clark Lake. So you know what? You got a canoe or a kayak? Go there. You got a speedboat? Go there. Anybody can go there. Let's not, it really does disrupt. That is the only major part of Clark Lake that is a natural habitat of a substantial size. So let's not make our kids and grandkids regret what we have done today. That's it.
Okay. Oh, do we have another one? Okay, please.
My name is Carol Hendershot. I have a home on Clark Lake. And when I look at it, it's, you want the 50 feet for access for 48, 49, the number seems to change, people. I have a home and I have 137 feet. Does that mean that I can allow in 50-foot areas as many people as I want to have access to the lake? The access you're giving is not just to homeowners, it will be, they'll have to come through there. People can, many people can use it more than that. We have not done that. Other people have not done that. It could be very crowded lake. So think about those of us who do use our lake carefully. We don't go on other bounds on other people's property. We would like to see the same respect, if that is there, that it be used by people who have their access, which we have paid for when we bought our home. Thank you.
My name is Charles Ramsbacher. I live on Clark Lake. I've lived on Clark Lake for property there for 39 years. I've been the past president of the Clark Lake Association. I've been on the board of the Clark Lake Association for many years. I and many of the people sitting in here and others on the association have worked diligently for years to keep this lake environmentally clean and safe and ready for our other generations as they come forward. Simply not going to repeat any more than that. I think you've heard enough, other than I just urge you to get the dock off that property. Thank you.
Good evening. My name is Carnegie May. I have a question for the board. If this is in violation of your original stipulations, how are you explaining why this is not being enforced when there is a violation already in place with the original proposal? I'll take an answer from anybody.
Brittany, do you want to?
Sorry. It comes down to the technicality of the labeling of the lots. So when the initial violation came forward, we were moving forward with a violation because of a dock placed on Outlot C, which was against the conditions. But Outlot C ends at Norway Lane. So then it became a dive into with Mr. Pearson, our city attorney, on what our legal rights are, what their legal rights are, and that's kind of how we've gotten to this point.
Okay, well then I would just like to express my thoughts on the entire situation. I want to thank you for allowing me to speak. It's been about 15 years ago since I spoke in this very room concerning a similar issue on the lake. And that was involving the protection of Clark Lake. I do believe that there is a responsible and respectful resolution to this somewhat complicated situation. I will be happy to share my thoughts on that at another time, another place. But tonight, I would like to say that I think there's a three-part solution to this. Number one would be the developers and his associates are allowed to sell their lots, build their houses, move on to another project, knowing that their residents of their development have a walk path to Clark Lake. The second would be the city of Nisswa. You're able to enjoy your long-awaited development. You can do your taxes, spend them to develop your city to the best it can be, and enjoy all the tourists that love to come to Nisswa. And the third would be Clark Lake. If you say no dock, then you're doing the right thing. We expect you to accept and understand from the city and the developer our concerns and our needs for no dock. The finding will help us maintain quality of the lake that we love. And the thing that we work very hard for to protect. Not only the lake itself, but all the wildlife that we see and enjoy. We have loons, geese, ducks, heron, fish, you name it, we hope we have it. The lake is home to all of us, to the residents that live on it and to the wildlife. I'm asking you to please help us, the residents, the association. Please help us out. We work hard and we'd like you to respect that and help us by saying, no, no dock. Thank you.
Any other comment? Okay, I will close public comments at this time. I just want to stress that in order to have a productive meeting now, they'll be talking from the attorney and then we're going to be asking questions. So I want it to be a productive meeting and I want to respect the process on how this is supposed to work. So I'm not sure if we want to start with Tom or Brittany. Okay.
I just wonder if anybody, excuse me, on the panel has any questions. I've written to you, we've been from last night, actually. I've written to you about this. We've been here quite a bit on this. And so I don't know if preliminarily anybody's got any questions about A, the outlot, C, outlot H distinction from 2006. B, the extension activity that was done in 2019. And the reasoning that can be applied to what our zoning ordinance says about this. So I wonder if there are questions first.
I did have one question. So in the original conditions, it said no dockage, permanent structures, or motorized vehicles. In the pictures that were submitted, they show dockage going across the wetland. Does it include that in the no docks, or is it just considering riparian dock? Do you understand what I mean?
No, I don't. Which restrictions are you referring to?
We received information
From the Clark Lake people, yeah.
yes,
You're looking
and
at pictures there.
pictures, and it shows dockage through the wetland. And it's essentially just a floating walkway is what it was considered, would be considered. But then you have the riparian portion of it, which is in the water beyond the OHW.
Yes.
So, and Brittany may be able to answer this too, would this part be considered part of the dockage or permanent structure?
That would be my interpretation, just because typically within the DNR, they would consider that part of your docking structure to access water. So I would consider that one.
Okay.
And just to add to that, I don't know what the planning commission knows, so I don't want to insult you if you know the details, but DNR has issued a permit for this activity. Including, I would assume, although I have not researched this or checked into it, but including whatever that structure looks like. Do you have any other questions about that or?
No, that was mostly it because a dockage, I'm gonna just call it dockage, across a wetland as a walkway is actually, from a wetland point of view, is actually a good thing because you're not compressing the soil. That's why I wanted to know if it was considered a part of the entire system, or if they would be allowed to keep that up to the riparian, up to the water edge. That's mostly of my question, because it would actually save some of the wetland from being compressed from people walking across it if they were going to.
If that access structure was allowed to remain, is that what you're saying?
Yes, yes. And then nothing lakeside.
Right. Okay. Does anybody else have any other questions?
I have one question about your particular communication with us. It talked about some ambiguity in the language, and I didn't quite understand all of that, but prior to that, maybe I'd just like to make a few comments just to keep the record clear. We are a planning commission. We're not a council. There was some comments earlier. We recommend to the council action on this, and we do not decide up or down.
No, it's a conditional use permit.
Oh, it is ours then? It's
Yep.
not a recommendation to the council?
You are it.
Okay, I take that back.
That's why we're here.
Take that back. All right, but just to keep the record clear, this whole situation seems to be a combination of two things. One, the combination, we got a developer who's ignored the original dictates of the developer's agreement by adding the dock without permission and at a later date. And it was based on semantics, which was the naming of outlots between the preliminary plat and the final plat. And that the original preliminary plat showed C and the final plat shows C and H, I believe it is. So there was actually two of them. So that was kind of taking advantage of a semantics problem that occurred because of that filing of the plat. The other side of that is that the city erred, as I see it, in 2006, when the final plat came in, the city staff or whoever was, didn't catch that. And that developer's agreement should have been corrected at that time. So we've got two sides to this thing that they're already a problem. They talked about, one of the residents of Clark Lake mentioned due process. And there's been, about the need for due process in a subject such as this. And the due process on this has been almost unlimited to date. Hours and hours have been spent by both you people and us on discussing this and reading it. I mean, the material alone for the Planning Commission has been voluminous over several months. And it just doesn't seem to end, and a lot of dollars have been spent. You people have spent dollars on legal costs. We're spending dollars, on the city is, on legal costs every single day that this goes by. And we really need to bring this thing to a close. And something that's to a point that makes sense for everybody. And I'm more of a person that tends to want to compromise on things. I realize there's people in this room that don't want any compromise, and there may be others that do, that are willing to do it. But this particular dock, as I see it, is going to end up, if the dock remains, this dock is going to be a people's dock. It's not going to be a boater's dock. I mean, it's going to be very clear in the language that that's where it is, that you will not see boats moored out there that have motors on them. And if it does happen, there should be conditions, and the condition should be that it gets terminated immediately or within 30 days of notice or something like that. And so far as dock extensions, I see no reason that we can't just preclude that. We cannot have dock extensions on this, and we can make that part of the agreement as well. The Clark Lake attorney passed out a list with a number of conditions on it. Most of them are included in what the city attorney has also given us in his documentation. The last one, I think, that came in from the Clark Lake people is, the last one is any breach of any condition automatically voids a conditional use permit in its entirety. And I would totally back something like that. So it's, so I agree with that, as well as the other conditions as well. I don't think any of them are unreasonable in this case, because we've got to end up with something that doesn't end up back here next year. There has to be a way for when the complaints come in, if there is one, if there's a violation of it, that the staff can handle it, because it's all in writing as to what is right and what cannot happen. So I just wanted it in the record, and that's my comments. So.
Tom, can I jump in to ask you, are we able to void a conditional use permit in relation to a PUD? My understanding was it couldn't be done.
Well, it's really, I would just say that a lot of these conditions, alternatives, I would say, that proposed by the association match what the developer proposed.
Yep.
That one doesn't, and I don't think I could back that one, just because if there is a violation, let's say the dock remains, and let's say there are conditions along the lines of what's being talked about here, and those some condition or some conditions get violated, we have open to us a lot of different enforcement avenues, but they would all involve, if it doesn't get rectified upon notice, if a violation doesn't, then bringing the applicant in for their due process to speak to it before a decision is made. A CUP is a property right. And so automatically voiding something without having somebody have a chance to defend it and put their side in isn't something I would recommend. But this isn't off track. The idea of what the city would do would be to use all of its enforcement efforts available if there were any violation of the conditions.
Can we go as far as if there are violations that happen once or twice or even once, doesn't matter, I guess, at this point. If there are violations and there's motorized boats moored at this dock, that we can condition that the dock be removed? Can we go that far rather than just voiding the conditional use permit?
Well, no, again, because the dock being present is part of the CUP. And so any unilateral without notice and due process thing that you might try to do would be really hard to do at that point. However, what I would say is that if the dock is allowed to remain and these sorts of conditions are placed and there's a violation, I'm guessing the city's going to know about it pretty quick. And I'm guessing, given the background that's here, especially also true in the city's part, that if there were violations of these conditions, motorized use, the city wouldn't need to be prompted too hard to move to enforce, given the history and the nature of all this.
Okay.
Can I speak for a minute to the ambiguity thing? Because I think it's important.
Yeah.
It does really.
Yeah, because that's one question I have.
It does really bring into focus why the discussion turned the way it did, okay?
Okay.
We have the outlot C, outlot H distinction. Outlot C was prohibited from any dockage or anything else. Outlot H was silent. We know that happened. We don't know how it happened, but it did happen. And I would characterize that, as you did, as a mistake somewhere, somehow on the city's part in 2006 and not seeing how that matched. But we are here now with a technicality that says outlot H is completely unregulated. And this dock is on outlot H. So it isn't so simple, unfortunately, to say that there's a violation because the dock is there. That's not technically correct. The ordinance provision that we have, which I'll tell you will be on Brittany's and my high on our list to get this fixed. This is along the lines of things that you spot in your ordinance that don't work or don't work anymore, and something comes up. This is a very unique fact pattern. This ordinance provision is not written well. And it's easy to read the first part of it and say, well, if the work isn't completed within 2 years, it's automatically voided and we're done. The developer disagrees with whether or not the work was complete. Save that for a minute. The biggest problem with the ordinance provision is what appears to be exemption language on planned unit developments further in that provision. And this is a planned unit development. And that sentence is not written well. it could be and easily credibly construed to say that planned unit developments are exempt from this 2-year rule. And so what that would mean then, if that's right, is that 2006 CUP lives on without respect to whatever happened in 2019. Therein lies the problem for the city in this. Nobody will be completely happy. We have tried to broker a solution here that would answer the concerns that the city and the residents there have about the use of that dock. Harkening back to 2006, when it was clear that there shouldn't be motorized use there. Developer, and I'm not advocating for the developer here, but the developer here takes the position that they don't have to do anything with this CUP, that they still have it by virtue of that language. And if this goes to a courtroom, they might win that argument. They might lose it. But having said that, they've made concessions here, which to me at least, I'm not voting, but to me at least, appear to address what 2006 was concerned about motorized use there. And then if this is allowed to continue, the dock is allowed to stay there and those conditions are placed, then again, it puts a city in a position of being able to enforce against motorized access and motorized use. So I just wanted to be clear that each side of this, the developer and the association, both think from a black letter perspective that they are 100% right. And neither is 100% right. If that's due to a mistake that the city made 15 years ago, then that may be true, but we still are where we are now. And what you said earlier about compromise, I think there's been some effort to compromise this. And again, I'm not advocating for a result here. What I'm trying to do is keep everybody somewhat happy here so nobody ends up in a courtroom spending money over a dock.
Yeah, we've already spent way too much.
Yep.
I have a few questions. It was touched on, and I had thought I kind of wanted to bring this up. It was touched on some of the public comments regarding riparian rights. From my understanding in my own business background, when you have a PUD development on a narrow strip of shoreline that's 50 feet, what is the riparian rights in terms of the title and the legal work when it comes to the title work of the property itself? Do they have riparian rights? And that is kind of piggybacked on the fact that we are already going through this and a lot of other these similar issues with current developments where we have to go through wetlands. So I guess the first question has to do with riparian rights. Does this property have riparian rights?
Yeah, Josh, I don't know the answer to that. That's deeper than being able to just say yes or no to that. So sorry.
The other question that is kind of piggybacked on if it has riparian rights, you had said that they have obtained a DNR permit. I'm very familiar with that process. Kevin Martini and Danny McNeil in the county there. And when you have to make these channels, generally speaking, they go from the property lines out. I think that was brought up by one of the public comments. And this one is most definitely at an angle. Now, perhaps it's to the benefit because you'd have to go through more of the wetlands and more of disturbance, and you're doing more damage to the lake substrate in that way. But legally speaking, I guess my question is, shouldn't it be straight out rather than going at that angle across? I guess it's kind of an imaginary line where the property owner next to that outlot goes out.
Yeah. Well, the only thing I would say about that is I don't know what that looks like out there. I only got, excuse my image of what that looks like based on the comment from Mr. Mueller about how this one intersects with one that was already there, I think essentially was what he was saying. And I don't know that the property owner who had the one that was already there has any priority right or any right with respect to that area of public water. So I imagine that, and I don't know this, Josh, was not part of the DNR permitting process. I don't know what went into that. I can only assume that they looked at that and didn't object to it. And maybe it was because it was the path of least resistance, because to go straight out would have caused more disturbance. So I can only guess about that. The only other thing I want to say about that is I did not bring up that permit to suggest a result one way or the other here, or to advocate for anything, only to make sure that everybody was aware that you might have expected DNR to have a different view of this and they didn't, they permitted it. So for whatever that's worth.
Generally speaking, the DNR will issue a permit in most cases if there is owned frontage there. I guess it was just some gray areas that I felt. I was reading through the memo that you had sent us, and it has something to do with the existing dock structure on Outlot H. I think that's a little vague. Do we need exact dimensions of that dock structure? The question I have for that is, I don't know if Clark Lake is any different, but on the lake that I am at, we're down about 30 inches of the regular OHW from just no rain. We're to the point where we need to extend the docks out for people to get to navigable water. I'm not sure what the situation looks like down there. I wish I had the opportunity to go out there before the meeting, but I just didn't. Is that, I mean, is it even usable right now? Is it just sitting on the lake bed itself? I don't know if you can restrict something like that, because I mean, once we have a situation like this where we're in a drought, the dock is useful or useless. I mean, you can't use it at all right now.
Yeah.
So I guess I would like to know a little bit more about that, and if we're going to have it in the list of conditions, I just think that it needs to be a bit more specific, in my opinion. But
So you're thinking dimensions?
perhaps dimensions, or perhaps based on what the lake level is.
Well, yeah, as the developer has written, will not be expanded or extended. So I take that to mean to address the concern you have. But if the dock is to remain and conditions are being placed and you want dimensions on what's there to describe existing dock structure, that makes sense.
Okay. When this had originally come forward before the board, I was the person that said no. One of the reasons why I felt that is because a floating dock, in my opinion, does less damage to lake substrate than having to constantly dredge through that low water and turning up the silt. That's why originally I felt that, okay, this is probably a better solution rather than having people trek through. But I guess it comes down to what are the expansions here? I mean, I just think in the language, it just needs to be more specific. I understand that they don't want to have motorized vehicles down there, but does that count if they want to take the dock out? If you're taking the dock out, most times you're going to have to bring down some sort of mechanical machine to be able to pull that dock out of the water. Does that count? Do they have to go out there by hand? I don't know. So I guess that's all the questions I had right now, but maybe we can piggyback on some of that stuff. Is there any more questions from?
I think the idea of having the walking dock that goes out through the wetlands and through the Merkin-Meyer here, whatever you want to call it, is more of an advantage to the lake than not having that. And I think just the people from Clark Lake, if they go over to look at the Rice Lake creek coming through from Clark Lake over from Rice Lake, there's no walkway or anything going through that, but you go in there in the fall when the ricers are in there and the duck hunters are back and forth. That creek gets pretty mixed up. If you had a floating dock on it, that would get them out further towards the lakes. And it's just an example of what I think the dock saves destruction of wetlands. So, the floating dock. So.
Don, did you have any questions, comments?
Well, as liaison from the council, I have no vote here. I don't normally answer any questions. I'm just here if there's a question they have about what the council is doing or how the council is doing it, I can answer that. I assume some of you are sitting out there and saying, why doesn't he say something? That's because I'm a liaison. I'll just say one thing and leave it at that. Brittany sent a memo out dated August 18th. And in it, at the top of the page, she had 5 points, which I think are very good. I'll leave it at that.
You're referring to the conditions, the new conditions. Okay.
Mr. Chair, may I?
Yes.
So looking at those 5 bullet points that are recited in Brittany's memo and that are verbatim suggestions by the developer, and matching those against the ones that were distributed by the association's attorney just before the meeting, as I do that quickly, those are mostly on the same page. In fact, as I look at bullet point 1, the dock is for the specific purpose of walk-in access for non-motorized watercraft. No permanent structures are allowed, no motorized access whatsoever is allowed. Yes, that comports with directly. That could be added as another sentence to the existing condition in the developer's version. The second bullet point, motorized watercraft of any kind is strictly prohibited from launching from, mooring at, or otherwise using the dock. Yes, that is another concession by the developer, could be added as a sentence to one of those proposed conditions. Number 3, removal and replacement of the dock must strictly comply with all applicable rules and regulations. Again, yes, I think that comports with, to me, that's a no-brainer, but it comports with what the developer has recommended. So yes to that one. The next one, any purchase agreement or homeowners association governing document for any property in Pine Trail must contain all restrictions and rules for the dock as shown within the CUP. Yes, that comports with what the developer has suggested about changing their governance. The only caveat to that is I don't know that you can say what can or can't be in a purchase agreement. But typically purchase agreements aren't signed until buyers are aware of the association governing documents and how they do regulate the use of the property. So I think that's, although that wouldn't be specifically part of the condition, the rest of that all works. And I think the purchase agreement process would happen naturally. As I look at the next bullet point, if the association desires to change anything about the placement of the dock or the dock itself, the homeowners association must complete the reapproval process to amend the CUP. Yes, I mean, I think although that's not part of what was recommended by the developer, that would be a fact of the situation. The second and last bullet point probably is a no, because I don't think the city can determine who has standing to enforce a CUP. And I think that everybody probably can rely on the fact that if this happens and the CUP is revised and there are violations of it, the city won't need to be prompted or second chaired by anybody to enforce it. So that one can't be part, but I think it would happen anyway, that it would be, I know it would happen, that it would be enforced. And then the last one is what we talked about earlier, any breach of any condition automatically voids the CUP. No, we can't do that for the reasons discussed earlier. But again, the city's got a wide range of enforcement options open to it should this happen and should a CUP ultimately be violated. So that's a long-winded way of saying these suggestions by and large are ones that can be incorporated into the developers and they match them. And if there is a vote here to allow this dock to continue to exist and the CUP to be modified accordingly, then these things could be added to what the developer has proposed. The only other thing I would say is this. If you're talking about action items now, here's how I view what the options are. There could be a motion made to approve an amendment to the CUP from 2006 and deem that it does still exist by virtue of the ambiguity in that language, which exempts PUDs. That it does still exist per the ordinance provision, but that it shall be revised pursuant to the developer proposal as further revised by the association as we just discussed. That'd be one. A second one, if you decide that the dock should exist with these restrictions, would be a motion to approve essentially revisions to the 2019 extension, looking at that as really actually a new CUP application that was made and was granted in 2019. There were findings of fact and other things in the record there that wouldn't be standard to just a renewal and more like an application. Of course, the third choice would be to say that the dock can exist, that there is no CUB presently there, and that because of that, the dock must be removed.
I have a question for you and Brittany at the same time. Just so we're fair and consistent with everybody in the city. Let's say this development that's to the north of there requests a dock, what is the process? Do we have a city ordinance for that process? And I just want to make it fair
Yeah.
that we're treating everybody equally here.
In my research, I haven't been able to find any record of them not being allowed in access. I don't see why they wouldn't be allowed in access. I don't recall now because it's been so long since I looked at it, but I believe that it wasn't even part of their CUP as a limitation. So at this point, they
We don't
can
know.
put in a dock.
We don't know. I don't know the answer to that. But I will tell you that I'm not, as a city's attorney, I'm not moved by the idea that there will be a domino effect of associations coming for and successfully getting something like this dock. This is a unique fact pattern. This dock is only here but for an ambiguity stretching back 15 years. And I don't know that we've got another fact pattern like that in the city. I can tell you that I haven't seen one like that before.
As a discussion item in the next meeting, I would like to have some discussion about that. At our, I guess it'd be our, September meeting.
Discussion about what in particular?
Yeah, I would like to, there's some ambiguity there on what is allowed and what isn't. Perhaps we can talk about that and have a little bit more research done. Just so if this comes forward again, we don't have the same kind of problems.
I think that if it were to come forward again, it would be another unique situation.
Okay.
Mostly because anything that would come forward where, say, we have a new application that wanted to control the access lot, we no longer allow them.
Okay.
If there was already an association that has riparian lots that wants to put a dock out, we'd have to look at that fact pattern, but ultimately we'd make a decision based on that request.
Okay, thank you. Any other comments from the fellow commissioners? Yes.
Would you permit 1 minute?
Sure.
Thank you for indulging. I just want to touch on a couple things that I heard. In my opinion, there is a way for the city to essentially change the status of conditional uses. Your ordinance does reference the state statute, and it can be looked up later, of course, but 462.3595 addresses conditional use permits and duration. And that just indicates that a conditional use permit shall remain in effect as long as the conditions agreed upon are observed. When they're not observed, then a city can come in and amending official controls can change the status of conditional uses. And then you asked some good questions about the DNR permit. I was under the impression that the permit was for the channel, putting a channel in, not the actual dock. And that channel, I do personally think, just through my own practice in teaching riparian rights at CLEs, your riparian zone starts from basically the end of your lot line, yet you have an imaginary line that extends into the lake. And that could invite legal issues between that neighbor and the developer by cutting the channel arguably through a riparian zone. So that could be a civil issue between the neighbor and the developer. And then I would just ask, what exactly is the future plan from the developer? I'm hearing a lot of speculation. If we're putting all this effort in, it would be nice for the developer to be really clear on what the intentions are for the dock, not just a couple things that won't be done. And then finally, on these conditions, should you go that way, I would also urge you to put a strict timeline on the conditions, that they're not just open-ended. If he is to do those things, by what date? Thank you.
One more question. So this is Pine Trail Homes for this specific HOA. There's a development going on the other side of the road here by the same developer. It will not be, access will not be granted to this new development. It's for this one only. I just want to make that clear.
Correct.
Correct. And we also do not have any active applications at this time.
Okay.
When you are, how long does you have an HOA that wants development and they decide they want to do other things, are they restricted by this if it is passed?
If it's in the, sorry, did you want to take this one?
No,
Tom?
go ahead, you're fine.
If it is, if it's in the HOA documents, it will run in perpetuity. The HOA, my understanding, correct me if I'm wrong, could vote to change it, but ultimately through the city, the conditions remain indefinitely because a conditional use permit runs with the land forever. So,
The governance doesn't matter.
correct, yeah. I
Well, but-
also wanted to clear up the record on a couple comments that have been made about DNR regulations. We don't need to get hung up on it, but I've been told by a CO and a hydrologist that your property line ends at the lake shore. There's no imaginary lines into the water. I've been told this is a common misconception, not that we need to get hung up on that, but I didn't want it to sway anyway.
It can become, in my personal experience, it become an issue when docking is placed. So if a person has a dock on the water and then they go across this line, I've had issues in the past where that is not allowed, and I think that's why I brought it up. Okay,
Different thing, but
yeah,
yes.
it's a different circumstance, but yeah. All right, well, at this point, we need to have a motion one way or another. So I'll leave it to Kristen or Gary to do so.
It'll be a very complicated motion, right? I would make a motion to approve the revision of the original conditional use permit. This would be for both 2006 and 2019, the revised one. Is that what we're, motion would cover both?
I think to keep it cleanest, you would make a motion finding that the 2006
Okay.
CUP does exist and then going from there.
Okay. I'll make a motion then that the 2006 CUP does exist and it be modified to include the 5 bulleted items that are in the memo by the city planner, Brittany Connor, on August 18th, 2021. Then also add to it, there were 7 bulleted items that were drafted by the Clark Lake Association, and add to it numbers 1, 2, 3, and 5. Which would make a
Does he
total.
need to name those? You have it? Okay.
To item number 5 as recommended by Tom, though, I believe. Okay. Yeah, because we would have to remove that the homeowners association would have a right to reapprove the process of the conditional use permit because the city would be the governing body.
Okay, so excluding 5 then.
So 1, 2, 3.
And subject to those conditions.
I would like to make a suggestion on one of the conditions.
Okay.
That's on the staff recommendation. It's the 4th one. The existing dock structure on outlot H will not be expanded in width or extended in length. Very specific.
It's right there.
It is. The 4th one down, the existing dock structure on outlot H will not be expanded in width or extended in length. There is absolutely no question about what expanded or extended would be at that point.
I will accept that modification.
Do we also want to place a date?
Hold on, do you need a clarification on what those exact dimensions are at this present moment to be able to make that? Or can it be in that language?
Tom, is that something that we'd be able to add once we have the dimensions?
Yeah, so maybe to further revise your revision to say add no increase in width of current dimensions, and then we'll get those dimensions.
I would agree to that too.
Agree to that. Get that? Okay. That's the motion.
Do I have a second?
Second.
All those in favor?
Aye.
Aye. All those opposed? Motion carries. Any additional questions or comments? All right. I'll entertain a motion to adjourn.